Well, good afternoon, everyone. My name is Eileen Harris, and I'm the Executive Director for the Alabama Center for Dispute Resolution. And we are delighted that you're joining us today for our second series on our collaborative law practice, focused on team breaking down roles. And just to ensure that we have a good Zoom meeting, we just have a few ground rules on the slide before you. We just ask that you please mute your microphone and turn your videos off. We do have a chat box. So if you have a question for our presenters, we'll be monitoring the chat box throughout. So please feel free to ask your questions. We are recording today's program. The program is being recorded and will be placed on the Alabama Center for Dispute Resolution's website. We also will be sharing this with the Alabama State Bar on-demand CLE program. I believe it's called ProLearn. This course has been approved for 60 minutes of CLE credit. If you're joining us, you should have received the PowerPoint presentation that we're going to be reviewing today, as well as a link in SurveyMonkey to complete a program evaluation for CLE credit if you're seeking CLE credit with the Alabama State Bar. At the end of the program, I will be giving you a code to enter into your evaluation. And we need you to enter that code to verify your attendance. So that will be given at the end of the program. So thank you again for joining us for our second series on our collaborative law practice. We're so grateful to our sponsors. Along with the Center for Dispute Resolution, we have the Birmingham Bar Association Dispute Resolution Section, the Birmingham Collaborative Law Alliance, and the Dispute Resolution Section of the Alabama State Bar. And together we've been putting on a series of free webinars throughout the year, and there are 2 more in this series. So please visit the Alabama Center for Dispute Resolution's website and Facebook page for the next future scheduled dates for our trainings. And with that, I'm going to go ahead and open our webinar up to our presenters. And we're so grateful, great panel of presenters here with us today and very well qualified. And so, ladies and gentlemen, I'm handing it off to you.
Hello, everyone. I'm Frances Nolan. I'm a lawyer in private practice in Birmingham. I have a domestic relations practice. I'm going to let all of y'all introduce yourselves. Virginia, tell us who you are. Uh-oh, you're muted.
I muted myself because I'm at home in case the dogs barked. Sorry, Eileen, I know this is being recorded. I'm Virginia Miller. I'm with the law firm of Sexton Miller. I also have a domestic relations practice. I'll also do some probate work as well. And I have been collaboratively trained, or in the process of being collaboratively trained and learning the collaborative process since 2011, I think, because as we talk about a lot, and probably we'll talk about in this, just one training isn't enough. It's a lifelong process, and you learn more and get better every time. So, and with that, I'll hand it over to Caroline Taylor.
I'm Caroline Taylor. I am a therapist, so I'm an LPC. The majority of my work is done in the divorce arena. I have a kind of a diverse practice, though, with regard to the number of hats I wear, but one of them is a collaborative mental health coach. And in the collaborative process, I've been a neutral coach as well as one of the coaches in a 2-coach model, which we'll explain to you. I was trained first in 2011 with Virginia and have had several trainings since then. And it's nice to be a part of a process that is friendly and gets people to the other side in a more in a less adversarial way. So I enjoy doing the work.
What?
Hey, this is Quint Cook. I am a financial advisor with Level 4 Advisors and LPL Financial. I've been doing the working with the collaborative practices for probably about 10 years, about the same time as Virginia. And, my role as a financial neutral in this is to,
Well, listen, hang on, don't get ahead of us.
No, I'm getting there.
Okay.
In working with the attorneys. So, as well as mental health professionals. So, but yeah, I'm here in Birmingham, Alabama, and hope we can have a productive call. Francis.
Okey doke. Well, just to summarize, what collaborative practice is. I'm hoping and assuming that most of you have attended at least one of our other webinars, so you have some basic knowledge of what collaborative is. But just to summarize, it is voluntary, consensual, and non-adversarial. It is a very structured process in which the parties and lawyers agree that they will work toward a resolution outside of the litigation process. The cornerstone of collaboration, of course, is that if the process fails, the lawyers have to withdraw and new lawyers have to represent the parties in litigation. It's also unique in that it is a team approach that employs mental health professionals in the role of coach and financial professionals in the role of the neutral to do the part of the work that I think most lawyers hate, which is collecting all of the financial data and collating it in a neutral fashion to present it to the clients. So it's a very structured approach that is governed by agendas in meetings that are usually no more than 2 or 3 hours at a time. And it is designed to work through all of the issues toward a more durable outcome for the parties. Is there anything that I've left out in that summary, you guys?
I don't think so.
So with that said, I mean, we don't want to labor over what the process is in this seminar. We want to talk more specifically about the role of each individual professional on the team. So Virginia, I'm going to let you go first, even though it says I'm going to let Caroline go first on the slide, and talk about what is the role of a lawyer in the collaborative process.
Well, first of all, I want to say, number one, that to everybody on the call, that I'm doing this CLE with 3 of my most favorite people in the entire world, and we've also worked together. But with all that being said, that doesn't mean that in the collaborative process we can't get our feelings hurt or fuss at each other, or not necessarily. We don't always necessarily agree with each other. So with regards to being the attorney in the collaborative process, it is a complete paradigm shift. And we talked about this a little bit last time in our first seminar, where we kind of gave an overview of the collaborative process. We did that back in March, and I believe that Eileen has that recorded. You can probably view that through the Alternative Dispute Resolution website. But like I said, complete paradigm shift. Very, very difficult, even for a lawyer like myself that I think has more than one speed, and I don't necessarily idle in the most aggressive state all the time. But understanding what my role is has taken a lot of training, and that's why I sort of started off by saying I did one training in 2011. Since 2011, I have had many, many, many trainings, and I think I've gotten better and better at it. But I think I probably had 3 trainings. And when I say trainings, I don't mean 8 hours. These trainings are 3 days. And they're usually in 3-day increments. And I think it was probably my 3rd training where I really started, the light bulb really started going off, and I really started getting it, so to speak. But my job is to really create options for my client. It's not to tell you what the law is. Obviously, I do that. The lawyers do say what the law is, because obviously any agreement we reach has to be within the bounds. It can't be illegal. But you don't have to say, okay, well, in the state of Alabama, you're not going to get more than 50. I don't say it like that. You're not going to get more than 50% of the retirement. People can agree to more than that if that's what's going to meet their needs. I think it's more about me having conversations with my client about how their needs are going to be met. really having conversations about not focusing on the past and what has happened and operating in that space, but what do you want your future to look like? Because obviously, if you want to do the collaborative process, and as Francis very well defined it, that's a different process. We're not going to sit and talk a lot about, or hopefully not talk a lot about and rehash all the ins and outs of that. We're trying to get a plan and for going forward. So it's different in that way. It's also different in the sense that when you are in collaborative meetings, if Francis and I are the lawyers, I can speak to Francis's client at the meeting directly, which is something that we're not normally used to. Francis can speak to my client directly. We can have, I don't call Francis's client on the phone outside of the meetings. Most of the communication occurs within the group at those meetings. But of course, the lawyers and the mental health professionals, the financials can have debriefing meetings and pre-meetings and things like that without the clients. But during those meetings, I can speak directly. That's different. And it makes you feel a little uncomfortable the first couple of times you do it, because you feel like you're doing something bad. Somebody's going to make a phone call on you. You're going to get in trouble. It's uncomfortable having those conversations. It's also uncomfortable having the lawyer speak directly to your client and not feeling defensive. You have to make this shift where you're not this zealous advocate just standing there on the castle wall defending your client. It's a very open conversation. Of course, it's a confidential process too, so that helps, but not aligning myself with my client, and also feeling comfortable calling my client out in front of other people when I don't think they're listening, when I think they're picking their fingernails instead of listening to their spouse say something very important, me sort of calling them out like the teacher and saying, are you listening to this? It's very uncomfortable in the beginning. And those are some things that I think are pretty different, and also not getting caught up with what the law is. And a lot of times your clients will always want you to go back and say, but the law says this, but the law says this. Or, you told me this was, and I said, well, yeah, I did, but that we don't have to agree. We can do whatever we want. It's a pretty free process in that sense, which again, makes you feel very uncomfortable after you have been practicing law in certain ways for a period of time. So I think that was some of the biggest change and shift, and very uncomfortable for me in the beginning, but certainly not defending my client to the death. Now, of course, I'm going to defend them if I think somebody is being unreasonable or speaking to them unreasonably, and we can take a break. But also the other shift is, and I can't believe I wasn't going to speak to this, that attorneys don't normally have, is you have a team. You have all these people on your team and they're supporting you and you're supporting them. And we don't usually have that. It's like we're playing a singles tennis match most of the time with no support from a team. And it's like Francis and I were talking about before the CLE started. Once you do it with a team and you have that support as a lawyer, and you don't feel that you were isolated all on an island unto yourself with your clients, so to speak, it almost makes it more difficult to go back and do the other way, because it does feel very isolated and very lonely. And it's helpful. And I'm not saying it's always one of these things where people are, patting you on the back and everybody's in agreement. Sometimes it's hard. Sometimes it's hard when the other lawyer has to say, you were derailing this process. If you don't start helping your client more, you're going to derail this process if you keep aligning, or the counselor or the mental health professional, not a counselor, the coach, or the financial neutral says it to you. Any of these people can say those things to you, and you need to listen. Those kind of things in the group dynamic. Go ahead, Francis.
What I was going to say is, I think one way that I might try to summarize what you've said is that one of the biggest differences between our role in the traditional process and our role in collaborative is that we tend to be very outcome focused in litigation. Rightly or wrongly, I think we can tend to have a lot of ego wrapped up in outcomes. And our role as litigators tends to put more pressure on us about how things end up. And in collaboration, we are really called upon to let go of the outcome and let the clients drive the outcome, which is really kind of a paradigm shift. And also, you know what? I think I just lost my train of thought. What was I saying about?
That letting go of the outcome.
Yeah, we have to let go of the outcome. I lost it. Never mind.
You know, you were talking about letting go of the outcome and how in litigation we're so driven by the end result. And it's client driven in the collaborative process.
Oh, right. Our biggest role in the collaboration process is to keep the process on the rails. So we shift our responsibility from outcome to process. And that is a huge paradigm shift. We become sort of keepers of this process to help people follow the rules, keep people on task, keep people focused on their goals, the outcome they want to create, which is different than in our role as a litigator, where we're really just focused on how is this all going to come out. So anyway, sorry, I had a brain fart there.
I was glad I could remember what you had just said.
Yes,
so
that was teamwork right there. So
Francis collaborating in action.
Yes. So Caroline, talk about the role of the coach.
So I think that the coach in the process, depending on, in Birmingham, I would say the majority of the cases I've been involved in are a 2-coach model. When you say, Francis, that's really
becoming less common, but I would say had been most common before.
So each client has a mental health professional that works with them and their attorney, and kind of what Francis said, tending to them and moving them through the process and the structure. When you are the only mental health professional in the team, there is more of a managing of the marital dynamic, because sometimes, unfortunately, the attorneys and also I think in the 2-coach model, a therapist can get pulled into the marital dynamic, and then it derails the process. So from that regard, the neutral coach keeps the process moving forward with the help of the financial person, and really tends to the client, helps continue moving the process and talking to the lawyers about any kind of mental health needs the client has, and reminding the lawyers of different ways to communicate with the people, the clients, given, whatever mental health issues they have. So it's very similar to what the attorneys do. And it is a shift, because a lot of therapists are advocates to a certain extent for their clients. And so it is, engaging in the team process, bonding with the client, tending to them, and then moving the process forward.
Tend to also be kind of the driver, more of the driver in the parenting planning process, wouldn't you say, than the lawyers or the financial person?
Yes. So working out the parenting plan, putting in place, temporary and long-term plans for the family, to minimize conflict and keep everybody congenial as possible.
And I mean, I guess we talk about our experience of collaboration has all been in the context of divorce. That is not the only application for collaborative law, but both locally, nationally, and internationally, for whatever reason, collaboration has had the most traction in this arena. The carrots and sticks are pretty compatible with a collaborative process, because people have investments in relationships that will continue after the divorce, there's some value in having a process that tries to preserve what's good between the parties. And that's probably why divorce has been the area of law that has had the most traction and collaboration. But again, that does not mean it's the only place that it could be used. It could be used in any legal context, but just as an aside. So Quint, I know we see your name as Conrad, but your name is really Quint. Talk about your role. That I interrupted you. You were about to say about your role as the financial neutral in collaboration.
Well, I mean, hey, look, everybody who hadn't been touched in some form or fashion by divorce, whether it's a friend, a family member, or ourselves, we've all seen it on TV and whatnot. There's plenty of preconceived thoughts about how divorce goes. We've all heard the stories of, I took him or her for everything they've got, so forth and so on. That world doesn't exist in the collaborative process. And, a lot of divorcing couples are often unaware of the financial implications of various settlement options. So my role as the neutral is I am an impartial facilitator as well as educator. The neutral, whether it is me or if Caroline is serving as a neutral, we usually run the meetings as neutrals, but it is still a team effort. When we're gathering information, I go through as the neutral. I gather information about the family's finances, incomes, expenses, assets, liabilities, get valuations on businesses, assets, real estate, collectibles, and I trust but verify. I do request documentation on all things that we discuss financially, and compiling that into detailed financial reports that everyone in the room, everybody on the team sees. And this helps us to discuss what lifestyles look like, what are the assets that are out there, what are some of the financial goals, priorities, concerns that individuals have as they're going through a divorce process. I mean, keep in mind, we're taking a household, whether it's one or two income streams, and we're dividing those, and there's going to be new expenses. There's going to be two sets of utility bills. What happens with the disposition of a house? I'm not the attorney and I'm not the mental health professional. I can't give legal advice, but I can assist the team members as well as the clients in looking at what may be some solutions to some problems financially. Maybe there's some alternative options. As was mentioned earlier, it's not necessarily always like a 50-50 split. Straight down the middle. There may be variations of property settlement versus alimony, spousal support. My role is to be the fact gatherer, do the analysis, educate everybody on the team, as well as the clients. It's not unusual for one individual to be much more knowledgeable about the financial situation of the family, and the other one has no idea, never dealt with.
It's not unusual, is it, Quint, for everybody to be ignorant of where the money goes?
Oh, absolutely. Absolutely. We see that quite frequently. So, in going through, and it depends on how deeply we've got to delve based off of the information that's needed to be gathered. Some people just the couples need to be told what it is that their expenses look like, because they have no idea. They just, the money comes in and it goes right back out the door and they can't tell you where it went. So we go through and we look at that. Then we look at, as we've gathered all this information, and these, my spreadsheets or documents become somewhat of a guide or a resource to the attorneys as they're looking at and discussing settlement options. We want to make sure that we're taking patient, along the line, but to be able to go through and look at either one of the parties and say, okay, here are the short-term, midterm, long-term consequences of this settlement. Is there going to be frequently there's not enough money in the bucket for all parties to maintain the lifestyle that they once had, but they can make an educated decision on that settlement before signing on the dotted line and then finding out down the road that it wasn't something that they expected.
Well, let me interject too, that we probably harped on this a lot in the first webinar of this series, but one of the biggest paradigm shifts between collaboration and litigation is that if we are doing the work the way it is intended to be done in collaboration, we are not doing positional bargaining. No one is trying to win. We are trying to shape outcomes around the parties' stated goals and interests, which is the sort of hard work of the beginning of the process, getting the clients to articulate and identify their shared goals and interests so that we can develop what becomes effectively a mission statement that is the filter through which all options for resolution are fed. So that at the end of the day, hopefully the outcome is one that meets the needs and interests of the family and is not just some competitive outcome that has been generated so somebody could win and feel good about themselves. Does that make sense?
Yep, absolutely.
I didn't mean to interrupt you, but I just want to make that point.
No, you did good.
So are we ready for the next slide?
Mhm.
I think this question, we've decided there are actually two questions that we could probably answer in tandem, is to have each of you speak to the pitfalls and the benefits of, oh wait, I got ahead of myself. No, go back. I'm sorry, Eileen. First, we want to talk about how your role differs. To the extent that you have not already mentioned this, how does your role differ in litigation than it does in collaboration? I know that, Virginia, we've already spoken to that as lawyers. Quint, can you talk a little bit about how you're involved in divorce cases that are contested as well as in divorce cases that are collaborated? What's the difference in your role?
Well, the big thing is in collaborative, I'm actually working for the betterment of both individuals.
Mm-hmm.
I look at it from the standpoint, or any neutral would look at it from the standpoint of, especially if there's kids involved, there's still a family, there's still going to be communication. And so you be that impartial person, it does not matter to the financial neutral what got us to this point. That's my role as the neutral is, how can we get to an acceptable settlement that meets or approaches both people's needs? In a traditional or adversarial divorce, my job is to gather the information for the attorneys. What can we do? I'm going to get as much ammunition as we can, because in that particular case, we want to win.
Well, and you're looking out. You're looking out for one person's interests in a vacuum as it relates to the other person.
Yeah, yeah. So
and-
I'm just working individually with that person and their attorney, and that's it.
And I guess that would
Without
be,
regard for the other side.
that would be a good way of summarizing the difference for all of the various professions. Rather than being only focused on the person for whom you're advocating stated position, you're advocating instead for the stated mission of the family, which is a real big sort of paradigm shift. Caroline, you do a lot of parental coordination. You do a lot of divorce coaching for, parenting coaching. Like you referenced, you wear a lot of hats, and I will say you wear them all very effectively. What would you say, what do you see as the biggest difference between your role as a collaborative coach and the role that you play in some of the other sort of hats that you wear? Is there more similarity for you, or is there a difference?
I think it is a lot more similar. So
Yeah.
it's not as much of a shift for me unless I was, testifying maybe as an expert for one person or another. That obviously is a big difference. But since I do a lot of co-parenting counseling and family counseling and divorce situations, the overall goal with all of my work is for the betterment of the family and the children, and to decrease conflict and help people learn skills to communicate effectively after they're divorced or when they're divorcing. I think that the one thing that is very different is the team approach. And that's what I really like about working in collaborative practice, is being able to have, attorneys and the financial neutral to work with to build the structure and help the family move forward. Because when I'm doing that in litigated cases, sometimes there are attorneys that are much more zealous advocates than than I would like to work with. So it is very helpful in getting a positive result to have that team atmosphere and have attorneys that want to see the whole family be successful instead of advocating for their client.
Yeah. Well, and that's a perfect segue to our next slide. We're not going to read to you guys from these slides, and we may have said things that are different from the slides, and I hope that you will take what the slides say as being important points as well, even if we haven't touched on them all. But, there are certainly some pitfalls to collaboration, stumbling blocks, just, there's also some misconception about it. But there are also some benefits. So that's not on our slide, but we did decide right before we started today that we wanted to talk about both the pitfalls and the benefits. And I think we all agreed that the team is a huge benefit to the collaborative approach. Virginia, what would you say are the pitfalls of collaborative practice?
Well, I think number one is, my biggest one, and the one that always comes to mind, is obviously, I've already touched on it a little bit, is the issue of acting as you would in a litigated case, feeling that you have to defend your client, feeling that you have to speak for your client. That's really difficult for me, because I feel like as lawyers, we feel like we have to speak for them because we're always protecting them. And this is not a situation where they need to be protected. They voluntarily chose to enter into this process because they want a different process. They don't want this sort of antiquated litigation process that is somewhat medieval in some ways, because it's so tortuous to them.
But this is a paradigm shift for the parties too.
Yeah.
And
yeah.
So they don't necessarily make the shift in one stroke. Like they require constant tending and reminding what the rules are. It's not like we only collaborate with people who are perfectly already oriented toward being collaborative, right?
Correct. So, I mean, right. So they're going to try to drag you over onto their island with them and get you to become positional with them. And so that's why a lot of times we always have to go back to, this was your participation agreement. Remember when we all sat down together, we all signed this together. We all said we were going to act as our highest and best selves. You are not doing that. And then you are pulling me over and I am not going to do that. I'm going to start acting as you are acting. And then all of a sudden we're going to derail this process. I think another pitfall is probably not sort of helping your client, like what Francis just talked about, not helping your client in the way that they need to be helped for them, even though they want the process, trying to help them through the process. For instance, I can think of a time when maybe I wasn't being as helpful to my client as I should have been. And Francis called me and said, your client constantly going back home after these meetings and trying to, go behind the process is going to derail this process. It is hurtful to the process. And so I would have to have and then sometimes I would feel intimidated by my client a little bit, having to go back but it was helpful, but at the same time it was intimidating. And so a pitfall in a lot of ways could be not becoming defensive with Francis trying to help me. A lot of lawyers, we don't like to be told or that we're not doing things correctly. So you can't become defensive. Becoming defensive and not sort of at least taking it in and processing it can be hurtful, and that's a pitfall. Also, being intimidated by your client who might be wanting you to act differently, like in the old paradigm, and not acting like you should in a collaborative way, it is a pitfall.
We don't expect ourselves in litigation to build bridges of trust necessarily with our opposing counsel. I mean, I think those of us who have collaborated for many, many years have probably incorporated more of this approach into all of our work. But generally speaking, you don't think of that as being a duty to the process, but it is. In collaboration, you really have to get along with your team members. You have to listen, you have to trust, and you have to keep the clients on the path, because they will not stay on the path any more quickly or easily than we have. And they haven't had years and years of training like we have.
It's really, really true. So I think those are, for me anyway, I mean, Francis may experience other pitfalls or, trying to avoid getting into those traps. Other collaborative lawyers may experience other pitfalls. I think one pitfall too, and Francis could probably talk about that. I think she's had more experience with this than I have, but when you have a lawyer who may have been trained, but they are not acting, they've not made the paradigm shift. So you get in these meetings and you've got your client and, everybody's in the quote unquote Will Ferrell trust tree, or, you're in the container, and you have this lawyer acting very much like they're in some kind of cross-examination process in the middle of a very heated trial, and
very destructive.
It's very destructive. You are trying to act as your highest and best self. And so let me switch it. So turning that into a positive, that's why like Quint and Caroline being there is very, very helpful to you as a lawyer. It's really probably more helpful for them to actually say something or ask to take a break, and have them actually, along with yourself, not confront, but ask questions like, hey, the mood really shifted there. And, where's this coming from? And so changing that into a benefit can be a pitfall. And it can also, obviously you have this whole group dynamic, and Francis may want to talk about some of that, about the group dynamics and the way all that shifts and changes with folks, but having them to be able to try to help the process get back on track. Anyway, and also, I mean, one thing we haven't talked about, but one of the pitfalls is, it's a benefit that the parties get to dictate how quickly or slowly the process moves. Usually somebody is always psychologically lagging behind another party. Somebody's always probably been thinking about the divorce or preparing for it a little sooner than the other one. But sometimes, you have people, if people aren't getting their documents to Quint when he's like, okay, I'm going to put he makes very beautiful spreadsheets, very, very helpful reports. They're amazing. But obviously he has to have the data to be able to do that. And so when you have a client that acts like they're too busy or just won't get it done, or maybe they're depressed, I mean, as a team, that's something that really has to be addressed so people don't start sort of harboring resentments. And then let's just say Francis's client is like, look, I was ready for this to be done 6 months ago psychologically. What the heck is going on? So also just having that help from the other team, I always go back to having that team, and that support is always really, I think, the basis of a lot of the benefits to the process. And with that, I'll turn it over to Francis, because she might have some good things to say about pitfalls and group dynamics and things like that.
Well, I would say divorce generally always confronts us with the fact that one party is ahead of the other. Whether you're litigating or collaborating, you always got to contend with that. You can always have laggers that you have to respond to. And collaboration requires you to wear different hats and use different approaches to try to address that than you would in litigation. You don't have a motion to compel or a subpoena or that kind of approach to resolve impasses that relate to discovery. So we have to work as a team to try to tend and move the parties along the process without making the slow person go faster than they can actually go, and without making the fast person slow to a speed they can't tolerate. It can be a challenge. Caroline, you probably are the most qualified to speak to what I think is the biggest pitfall of collaboration, which is the whole transference, counter transference dynamic that takes place. You want to speak to that? I mean, I think that probably is not something that we ever talk about in training to be litigators, that we're dealing with nonetheless, but that we really see the impact of in collaboration.
So I think when you're talking about transference and counter transference with the team, as far as getting caught up in the marital dynamic. Okay. So I think that this happens in litigated cases as well. In fact, I've seen it happen in litigated cases where the attorneys that are involved or any mental health professionals start adapting to the dynamic of the parties that are divorcing. So if it is, a controlling, dominant man who has a really submissive wife, then often the attorneys will adopt the same style or get caught up in the dynamic of how the parties interact with each other. And so as a mental health professional, especially in the one coach model, it's important for there to be trust. So Virginia touched on trust some, but trust within the team, so that when it comes time to say, hey, Francis, I think that you're really adopting your client's point of view here, and you're not seeing objectively what's going on with this dynamic. Can you, kind of take a step back and look at what this woman is saying about being really afraid that she's going to have to uproot out of her home and all of these, she's supporting these children and, blah, blah, blah. So it's important to help the lawyers to kind of pull out of, and anybody in the team, really. I think that it can happen also in a two-coach model, and it can happen in a one coach model, but I think it happens a little bit less because the job of the coach is to be more objective. It's having those tough conversations within the structure of the team with the lawyers and with the parties, so that you can adopt a new way of communicating that's outside of what that marital dynamic is. Because, in all of the work that I do, whether it's in collaborative or in just my day-to-day seeing clients, I'm trying to give my clients the tools to communicate differently post-divorce or while they're divorcing. And so it's important to identify what the dynamic is in the collaborative process with all of the team members and the clients, so that you can kind of realize what's going on, stop communicating that way, and rely on the structure and the trust in the team to move forward positively.
Yeah. And I would say that is probably the hardest part of the work, wouldn't you?
Yes, it is.
I think that when we first started collaborating, and I guess I got my first training in 2008. I think we had our first big training in Birmingham in 2011, and we started collaborating in 2011. There was this perception that we were trying to do this really touchy-feely, kumbaya, thing that was, I don't know, that's for sissies. That's for people who don't want to litigate because they're fraidy cats or whatever. And I mean, having done all of the work, having litigated cases, having collaborated cases, I would say collaboration is by and far and away the hardest work that I ever do. But it is far, far more rewarding than the litigation work that I do. While I would say that any fun that I have in litigation would just be probably my own personal fun at the expense of someone else, the idea of working as a team to really help a family to align an outcome with their goals and interests it's very rewarding work. You feel like you are part of the solution and not part of the problem, which is, I think, very, very rewarding. Is there anything that that has not been said by anybody about the benefits to you as in your particular profession of working as on a team versus working solo?
Is there anything
Well,
that's been, what are
well,
you?
Like, what are the benefits to you
the
as a
benefits,
professional?
not the other pitfalls.
Yeah, I think we've covered the pitfalls. What are the
Scheduling.
bennies? Did we not cover the pitfalls from your perspective, Quint?
No, Virginia did mention, getting the documentation and whatnot. But, there's, from the neutral standpoint, one of the pitfalls is it seems like, not all the time, but occasionally, where one client feels like you're siding with the other client more, you're taking their interests more than the other. And that may exist at one stage, and then a little bit further into the process, now the other person thinks that you're favoring. But that is where, having that team that jumps in. Scheduling can typically be a big issue, because it's not just the attorney and their client. Now we're
That's
talking
true.
about trying to get
Yeah.
2 lawyers together, 2 clients together, 1 or 2 mental health professionals together, 1 financial neutral, and everybody can pick a day and a time that works for everyone. And this does kind of go back into, well, from the financial neutral, it's not unusual for me just to meet with both clients individually without attorneys when we're gathering data or discussing data. Or I may meet with 1 client individually with the permission of all parties. And nothing hidden, nothing not disclosed, but maybe an educational piece. But and then you've got the standpoint of interference from outside sources. There's, again, like, people have their perceptions, whether they've seen it on TV or whatnot, how divorces go, and everybody's kind of got their 2 cents worth. So discussing initially, reiterating the fact that somebody needs to do their best to turn that off, shut that off, because they don't see the divorce process the way we're trying to accomplish it. So, and then things do tend to get or stray every now and then towards being positional when we start talking about the division of financial assets. But again, it's the team, the positive of the team, that can tend to pull that back together, especially when, Caroline can go through and help them work through what may be some hard feelings, bitterness towards what took them to this case, and work through it. But, thankfully, from the neutral standpoint, I get to take a step. So there you go, Francis. There is a big benefit to the team. For me.
Yeah. Anything else you want to add about benefits of the team, Virginia or Caroline?
I had a question for Caroline, actually, that was prompted by Quint. Caroline, as the MHP in your role and being a coach, you're not their therapist. And so have you ever gotten any pushback from people, like during the coaching process, if you were meeting with them individually or together as a couple, with them saying, well, my therapist said, or anything like that?
Well, so that is a common thing. And, I've completely spaced on bringing that up, but generally people, in my experience, who are interested in the collaborative process have had therapists and are familiar with the therapeutic process and still have therapists. And there have been times that I have had conference calls with clients' therapists about what's happening in the collaborative process to try to gain their support or help them understand what the process is. So when Quint was talking about outside influences, it could be a therapist, it could be a parent or a friend who is, saying this is the way it should be, this is what you need to be doing. But that has happened. And I have, tried to talk to the therapist, or even in one case, a psychiatrist, and educating them on the process and what we were doing to help the family get to a better spot. And it didn't end the way I wanted it. I was hopeful that it would, but yeah, that's been a pitfall for sure.
Yeah, I think, I don't know if this is true of all forms of litigation, but I have yet to be involved in any divorce case, and I can't count how many I've been involved in now, where your client doesn't have 49 people in their ear telling them how to do what they're trying to do. And while that has a really negative impact in any context, in any process, it is the absolute most destructive to the collaborative process, because we're trying to do it from a different perspective. And just about any Joe on the street, Joe or Jane on the street, is going to be looking at it through the traditional litigation filter. And they're not going to be able to translate whatever is being relayed by the clients about the process in a way that the person on the street is going to see clearly what's happening, or what the motivations or goals or whatever are. So I think it's a common pitfall to divorce in any context, but it is exceptionally destructive to the collaborative process. And when I'm really on my P's and Q's, this is something I talk to my clients about before the process ever starts. I talk to them very, very, strongly about the need to limit their sphere of influence and to limit the number of people that they have in their circle of confidence, for the benefit of themselves in the process.
One of the benefits that I can say directly from the team and from the process is that in the last 10 years, we've had, I don't know how many collaborative cases, but I can tell you that I've been involved in 2 cases that, because of the team and the process, they actually reconciled and stayed together and are still together today. because the team helped them communicate about what the issues were and the goals, and they found out that they were not that far off, but it was the team effort and the process that made that happen. Otherwise, if it had been a traditional adversarial divorce case, they'd have been divorced and they'd been hating each other probably by the end of this process.
Yeah, you can have amazing outcomes in collaboration. My most amazing collaboration story is the one where the wife actually got pregnant between the date they signed the agreement and the date the judge signed the final judgment of divorce. And for those of you on the webinar who are not lawyers, you need to know that legally the husband is the father of the child, even though he is not the biological father of the child. And so we had to come back to the collaborative process to try to deal with this third child. And we had the most amazing outcome. Long story short, the mother decided to put the child up for adoption, and they created this narrative for their family where the children could see the mom doing something to benefit those who couldn't have children. And rather than creating destruction and having, I mean, I can't even imagine the fireworks that would have ensued had that been litigated. We had a, amazing and beautiful outcome that probably would not have been possible in any other process context. So it can be an amazing thing. It can also just be a damn slog. I won't lie. I mean, there are times when collaboration doesn't feel all that better than litigation. It just is focused on, settlement, but not every one ends in some beautiful story, right? I mean, we've had some really, really hard work and some cases that crept across the finish line best they could, still better for the parties and for their wallets than a litigated case, but for those of us involved, not as rewarding as some collaborations could be. I mean, we don't need to try to make this into some fantasy story here. This is hard work that doesn't always end beautifully. But anyway, I think our hour is almost up. Eileen, do we need to open it up for questions?
Sure. So if you're on the call or the webinar, if you have a question, you can put it in the chat box. We found that seems to work a little bit better because we've had some unusual distractions in the past when we've opened the microphones up to everyone. I know one of the common questions that does come up is, where can I get more training? And so in the materials that you were provided, there are some links or some URLs to some websites where you can learn more about getting training, and different associations like the Birmingham Collaborative Alliance and the Collaborative International Academy of Collaborative Professionals.
That's a better website for trying to get training. Birmingham Collaborative Alliance doesn't have any trainings on the books, but the International Academy always has trainings. And there's a group in Virginia, Collaborative Practice Training Institute, that does a lot of trainings, and they're fabulous. We've brought their team here to train us. They're great. So look up CPTI.
And I was looking while we were talking a little bit, while other people were talking, there's some about trying to, for the folks on here, if they're looking for some training. And normally IACP and CPTI, I think part of their mandate is that the trainings occur in person. That's important. But I think with COVID, I think they've relaxed that rule. But I was looking online. I think there's a new group. We've never used them before. I haven't been to their trainings. They're called the Tampa Bay Trainers. They seem like they may have a training coming up if anybody wants to look at that. There was also another website called Roadmaps for Resolution. They look like they have a virtual training coming up in January of 2022, if anybody wants to start there. I didn't see much on the CPTI website when I looked as far as their trainings,
Okay.
or on IACP right now, but that's probably because there's not, they're not doing them in person. So anyway.
That's not my phone number anymore, but that's still my email address.
Okay.
I think we need to give the code for people who need to jump off.
Sure. I was about to get that out. First, I want to let folks know how to contact you all. Francis, if you want to give out your phone number, could you put it in the chat box? And this way people will have it. And while
Yep,
Francis is
figure out
doing
how to
that, I'll
do
give
that.
you all the code to enter into your evaluation. The code is 513. That's 513. And I want to again thank our panelists. This has been really an insightful webinar. And I think this is the first time we've had the attorneys, the financial neutrals, and the counselors on the call where we've talked about the importance and the role of teams. And so this has really been terrific. I also want to thank our sponsors again for helping to promote the collaborative practice of law, the Birmingham Bar Association Dispute Resolution Section, the Birmingham Collaborative Law Alliance, the Dispute Resolution Section of the Alabama State Bar, and for helping to make these types of programs available to everyone. Virginia did, is it Virginia's, that's Virginia's phone number or Francis' phone number in the chat box?
So Francis's is the 205-558-9930. And then my phone number was, it says 286 on the slide, but my phone number is 986-5050.
Okay, so forgive the typos on the slides. Hope everybody has their contact information. And again, thank you panelists for a wonderful job today. And with that, we do have some questions and I'll send them out to our panelists as we'll see if we can't get these answered and sent out to our participants for attending. But thank you all again. And with that, we'll go ahead and end the webinar. Thank you.
Thank you.